You've probably seen the rumor, maybe it popped up in your group chat, or you scrolled past it on your feed late at night. It's the kind of headline that grabs your attention instantly, making your heart skip a beat. The claim that the Supreme Court has suddenly, and without warning, wiped out every gun permit law in the country. According to these viral posts, overnight, every American supposedly gained the right to carry a gun anywhere. No paperwork, no background checks, no questions asked. It sounds dramatic, almost too dramatic to be true, and yet it's everywhere. Memes with bold text, Facebook posts shared by distant relatives, viral tweets racking up thousands of likes and retweets. The message spreads like wildfire, convincing more and more people with every share. But here's the truth, none of it actually happened. There was no late-night decision, no secret meeting, no emergency ruling that erased decades of gun laws in a single stroke. The Supreme Court hasn't issued any sweeping overnight order that makes gun permits obsolete. In fact, the court's schedule and decisions are public, and nothing like this has ever appeared. What you're seeing is a textbook example of internet misinformation, rumors crafted to go viral, designed to stir up confusion, outrage, and sometimes even fear. These stories are engineered to be shared, regardless of whether they're true. Yes, the Supreme Court has made important decisions about gun rights in recent years. Some rulings have changed how states can regulate firearms, but none have gone as far as these rumors claim. The reality is far more nuanced and complicated. Real legal change happens slowly, through lengthy court battles, appeals, and careful deliberation. Laws are challenged, argued, and sometimes adjusted, but never erased overnight by a single secret decision. Acting on these false stories isn't just risky, it can be dangerous. People who believe these rumors and carry firearms without proper permits can face arrest, hefty fines, or even more serious consequences. So before you holster up and head out convinced by something you saw online, remember, the real legal process is slow, complicated, and full of rules and exceptions. It's not something that changes with a single viral post. Don't let internet fantasies land you in real-world trouble. Always check the facts, look for credible sources, and remember, if something sounds too shocking to be true, it probably is. The phrase emergency ruling sounds dramatic, but in Supreme Court terms, it's just a temporary order. It's not a final decision, it's a legal pause, not a new law. These orders simply maintain the status quo while a case moves through the courts. They don't instantly change laws nationwide. When you hear about an emergency ruling, think the process is still ongoing, not finished. Misinformation twists these procedural steps into fake headlines about sweeping changes. The truth? The Supreme Court's work is slow and methodical, not a series of sudden shocks. Emergency orders are just one step in a long legal marathon. Understanding this helps you avoid falling for viral legal myths. To really grasp what's changed in America's gun permit landscape, it's crucial to understand the fundamental difference between may issue and shall issue permit systems. These two approaches have shaped how states decide who can legally carry a firearm in public, and the distinction between them is at the heart of recent legal and political debates. Under a may issue system, local officials, often police chiefs or sheriffs, had broad discretion to deny you a permit, even if you met all the basic requirements. You couldn't just fill out a form and expect approval. Instead, you had to convince the authorities that you had a good cause or a special need to carry a gun, something beyond ordinary self-defense. This meant that two people with identical backgrounds could get very different results depending on where they lived or who reviewed their application. In 2022, the Supreme Court's landmark Bruin decision declared these subjective, discretionary systems unconstitutional. The court ruled that the right to bear arms cannot depend on the personal judgment of local officials, and that ordinary citizens shouldn't have to prove a unique need to exercise a constitutional right. However, shall-issue systems remain fully legal. In these states, if you meet clear objective criteria, like passing a background check, completing a training course, and submitting fingerprints, the state must issue you a permit. There's no room for personal bias or arbitrary denials. Unfortunately, a lot of internet rumors and sensational headlines gloss over this important detail, leading many people to believe that all permit requirements have been wiped away. In reality, states can, and still do, require permits, background checks, fingerprinting, and mandatory safety training. The key change is that officials can no longer deny permits based on a vague sense of who deserves one. The process is now about meeting the law's requirements, not persuading someone in power. The real shift is from a system based on subjective permission to one grounded in objective qualification. If you check all the boxes, you get the permit, no special favors, no arbitrary denials. So, while may issue is gone, that doesn't mean gun permit laws have disappeared. States still regulate who can carry, and the paperwork, rules, and requirements are very much in force. Across the country, states are updating their laws and procedures to comply with the Supreme Court's ruling. They're not abandoning their permit systems. They're making them more consistent and fair, so everyone knows the rules and the process is the same for all. The rules are evolving, but permits, regulations, and oversight are still very much alive. Getting a permit still means following the law, meeting requirements, and staying up to date with renewals. So don't be fooled by viral posts or misleading claims. The truth is, the permit system has changed, but it hasn't vanished. In the wake of the Supreme Court's Bruin decision, the way courts evaluate gun laws in America has fundamentally changed. Now, instead of weighing the pros and cons of public safety versus individual rights, judges must apply what's called the text, history, and tradition test. This new standard means that, to be constitutional, any gun regulation must be rooted in the nation's historical practices and legal traditions, especially those from the time of the Founding Fathers. In practical terms, this means that if a law restricting firearms can't be traced back to a similar rule from the 18th or 19th centuries, it's likely to be struck down. Judges and lawyers are now poring over centuries-old statutes, colonial ordinances, and even obscure local rules to find historical analogs for today's gun laws. The old approach, balancing modern concerns like crime rates or public safety against the right to bear arms, is no longer the standard. Instead, courts are laser-focused on whether a regulation fits within the historical framework established by early American lawmakers. This has sent legal teams scrambling to research and interpret laws from hundreds of years ago. They're digging through archives, libraries, and legal treatises, searching for evidence that today's rules have deep historical roots. While the Supreme Court affirmed that the right to carry a handgun for self-defense is protected under the Constitution, it also made clear that this right is not without limits. There are boundaries, and not every restriction is automatically unconstitutional. States still have the authority to prohibit guns in what are called sensitive places, like schools, courthouses, and government buildings. They can also require objective, standardized permits for carrying firearms, as long as these requirements are consistent with historical practices. The Supreme Court didn't wipe away all gun regulations. Instead, it set a new rulebook. Restrictions must be justified by history, not just by modern policy arguments or public opinion. The result is a legal landscape that feels like a historical scavenger hunt, where the past holds the key to the future of gun regulation. As courts and lawmakers navigate this new terrain, the debate over America's gun laws is far from settled. States aren't ignoring the Supreme Court, they're scrambling to adapt. Former may-issue states dropped subjective rules and are beefing up shall-issue systems with new, objective requirements. They're adding more training, expanding sensitive places, and writing historical justifications right into their laws. It's a messy, state-by-state experiment, with courts deciding what sticks. The result? A patchwork of new laws and ongoing legal battles. States are trying to comply with the court while keeping some gun regulations in place. The process is slow, complicated, and far from settled. No Supreme Court ruling has stopped police from enforcing state gun permit laws. If your state requires a permit, police can and will ask for it. If you don't have one, you can be arrested and charged. Officers enforce the laws on the books, not rumors or online theories. The Bruin decision struck down one New York law, not every permit law in America. Until a court in your state says otherwise, your permit law is still valid. Don't risk your freedom on internet legal advice. Legal uncertainty is not legal immunity. The law is enforced as written, not as speculated online. Stay safe. Follow the law as it stands today. You might have heard that January 2026 is some kind of gun law deadline. It's not. Your permit won't magically expire then. That date matters because the Supreme Court is expected to hear a major gun case, Wolford vs. Lopez, around that time. Legal experts expect a big ruling in mid-2026, which could clarify the rules set by Bruin. Until then, nothing automatically changes. January 2026 is just a marker for when the next chapter might begin. The real changes will come from the court's decision, not the calendar. For now, the current laws and confusion remain. Here's the bottom line. A law is valid until a court officially strikes it down. The Supreme Court's silence or a pending lawsuit doesn't make a law unenforceable. Your personal opinion doesn't override the law. Don't act on rumors or online speculation. Stick to official sources. The legal process is slow and confusing, but the law on the books is what matters. Get your information from trusted authorities, not memes or social media. Acting on bad info can get you in serious trouble. Stay informed, stay cautious, and remember, only judges' rulings change the law.